I'm a partner with Mounty, Rakel, Hartley, French and Mudd, which is a law firm. We only represent people that have mesothelioma. We have about 80 lawyers across the country. We have multiple offices. We're national, and we just specialize in representing people that have asbestos-caused cancer.
Excellent. So give me the brief rundown of your history with this case.
So we represent a number of people that were exposed to asbestos from the Montana mines. Their exposure is to a variety of talc-based products, Gold Bond medicated powder, among others. We had sued before 1992. Pfizer owned that mine, and so we have often had clients who were exposed to asbestos from the Montana mine before and after 1992, and so in those instances, we've sued both Pfizer and Barretts Minerals. And we've been litigating against them in the tort system in state and mostly state courts for a few years. And in November or so, for the fall of 2023, Barretts Minerals filed for bankruptcy. Rather than file in Montana, where their operations are, and instead of filing in Pennsylvania, where their parent, Specialty Minerals Inc., is based and operates, and where their headquarters are, and rather than file in New York, where Minerals Technologies, who is their grandparent, is based, they filed in Texas, in Houston. And they did have one facility in Texas that arguably qualified them for some jurisdiction there, but to make sure, they set up a Barretts Ventures Inc., I think it's called, that's an affiliate of Barretts Minerals now, and they have the right to collect lease payments on land that they bought in a couple of hamburger restaurants sit on. So the profits from a Whataburger and a McDonald's are paid regularly to Barretts, and that's really all that Barretts is right now. It's a few people that are directors and a chief restructuring officer, but it has no employees. It doesn't make or sell anything. It doesn't have any operations. It is really just a few guys and a piece of paper that collect rent payments from these hamburger restaurants. And the reason that's the case is because Barretts sold their mine. They sold that operation to another company during the course of the bankruptcy.
And that was in 2024 to Riverspan Partners, correct?
Right.
Yeah. Thank you for that. And
over our objection, by the way. But we sorry, Bowen. We objected to the mine, not just me, but other lawyers and asbestos victims who are on the committee that represents all asbestos victims. We objected to the sale because it's an asbestos mine, essentially, and they're taking this poison out of the ground even now and selling it.
Yeah, I was going to ask, how is that possible? But I'm sure that we would really get into the weeds about that. So again, we'll just cut straight to the core of this, of why should Montanans care about this saga?
Yeah. So every state has the right to police the conduct within its own borders. And every state has obviously criminal law, but it also has civil laws too. And when someone in Montana is exposed to asbestos from that mine, because when these mines are operating, there's opportunities for there to be asbestos coming out of the ground, and there are billions of asbestos fibers in a sugar cube size metric. It's very dangerous. It's a known carcinogen. And so people that are in the area of the mine and that are working there are at risk of disease, of cancer. And people that are exposed to these products that are coming out of the mine. I'm sure there's plenty of Montanans that have used Gold Bond medicated powder with talc in it, and they will have been exposed to talc that was taken to asbestos from the mine in Dillon, Montana, that Barretts operated. And it really wasn't Barretts, it was Mineral Technologies and Pfizer that operated this mine. And that's the source of exposure for anybody who uses those products. And the reason I bring up the policing the own borders is that the law that controls the remedy that someone has when they get cancer is based on state law. So when a Montanan gets exposed to asbestos from one of these products or from that mine, their right to recover damages for that, for pain and suffering and their medical bills and what their family's going to be left with when they pass away, is determined by Montana law. And Barretts and MTI and SMI want to avoid that. They want to avoid state law, not just in Montana, but in New York and Pennsylvania and everywhere else. And they want one bankruptcy court in the Southern District of Texas to decide for all time what they are obligated to compensate people.
Thank you for that. What's next for this case?
So right now, victims are not able to pursue mineral technologies and specialty minerals. They can pursue them in the tort system in state court for only very limited theories of liability, for negligent testing, because what happened is Mineral Technologies owned the mine, and Specialty Minerals took talc from the Barretts mine and tested it for the presence of asbestos. And they failed to use proper testing, and they found asbestos, and they kept mining it anyway, and they kept selling it anyway. And the victims cannot right now pursue Mineral Technologies, who profited from this mine for 30 years and who boasted about it in their annual reports to their shareholders. The victims of mesothelioma, which is a very rare cancer that's incurable, they cannot pursue MTI and SMI for their own negligent behavior in the tort system right now. Those cases are all stayed by the bankruptcy order in Houston. We moved to dismiss the bankruptcy. There was a hearing on the 14th and 15th of April. We lost that motion to dismiss the bankruptcy, which would have allowed the victims to pursue MTI and SMI in state courts across the country. There are 22 states where these cases are pending, different states. And what that means is that someone who gets mesothelioma in Montana or California or Oklahoma or New York generally will sue in the state where they live and where they got sick and where they were exposed. And so there are cases pending across the country in 22 different states where people cannot pursue Minerals Technologies, which is a $2 billion company that can easily and fairly compensate the victims of their negligence, but they don't want to. They'd rather abuse the bankruptcy system. And so we moved to dismiss the Barretts bankruptcy because it's very clear that MTI and SMI, who are not bankrupt, are controlling BMI. This is a lot more than you asked for, Bowen.
No, this is perfect.
The bankruptcy court denied our motion. We are going to appeal that and hopefully get a reversal. In the meantime, the bankruptcy court has proposed that a U.S. district court have a hearing or a trial on whether there was asbestos in the Montana mines. And there are numerous reasons that that won't work that I won't go into, but that's what he's proposing. We've expressed opposition to that for several reasons. There is also a special committee that the debtor is proposing, meaning BMI, that this group of outside people, and they've nominated a few people. I think it's a little premature to say who's on the special committee, but there's the debtor is proposing a special committee to negotiate on behalf of BMI with MTI, its own grandparent, about the value of these talc claims. And I oppose that because, again, it's not BMI's decision what these claims are worth. MTI and SMI marketed this talc, they sold it, they trademarked it, and they're trying to use BMI as their stooge to get bankruptcy protection for themselves when they're not entitled to it. And so that's what's going on right now, is the victims are being limited and cannot recover from MTI and SMI, even though MTI and SMI could fully and fairly pay them. They'd rather not do that.
I think I've got everything that I need, but is there anything that I forgot to ask? Anything else you might want to add about all of this?
One of the things that is very important to someone with mesothelioma, and it's a very rare disease, but it's a very aggressive disease, and it's only caused by asbestos exposure. And many of my clients are relatively young. They're in their 40s or 50s. And it is so important to the person who's dying of mesothelioma to know that their family is going to be taken care of financially after they're gone. And so not only does any kind of a stay on their lawsuit, I have clients who have lawsuits in New Jersey and New York and California. So not only does the stay deprive them of compensation from MTI and SMI for MTI and SMI poisoning them, but it also deprives them of the peace of mind that maybe we're not getting compensation now, but I know that there will be compensation coming, and I know that we've reached an agreement or we've had a jury trial and I've won, and so I'm confident that my family will be taken care of. They are deprived of that, and that is a travesty of justice. We have the 7th Amendment, which says that you have a right to a jury trial if you believe you have been wronged. And jury trials are a check on corporate abuse. And my clients and anyone with mesothelioma with a claim against MTI and SMI has a right to have their case heard before a jury. And we will not stop fighting for these victims until those rights are vindicated.